Yes, we can start now.
Right. So, good afternoon, everyone. So, we have joined here today to discuss and deliberate upon the issue of the proposed Arbitration Council of India. Now, to just provide a brief background to the topic for consideration today, as we are all aware, the 2019 amendments to the Arbitration and Conciliation Act have been widely viewed as an incremental reform geared towards further refining and effectuating the intent of the 2015 amendments. One significant greenfield provision, however, within the 2019 amendment pertained to the establishment of this proposed Arbitration Council of India. Now, the seed of this idea in terms of the establishment of this council can be traced back to the recommendation in this regard as contained in the high level committee's report, which was set up under the chairmanship of Justice B.N. Sri Krishna to review the institutionalization of the arbitration mechanism in India. Now, this body recommended the establishment of such a council to undertake a litany of tasks to further improve the arbitration ecosystem in the country, with a specific focus on promoting institutional arbitration and laying down a framework for its regulation. Now, the formal enunciation of this idea can be seen in the proposed text of sections 43A to 43M of the Arbitration Act. Now, I use the word proposed here in the specific context of the fact that these corresponding provisions of the 2019 Amendment Act, which would in fact have brought into effect the aforesaid sections, have not yet been notified, in marked contrast to the majority of the provisions. Now, be that as it may, the proposed Arbitration Council of India has been tasked with the performance of a wide range of functions, which constitute cumulatively have the potential to significantly alter the arbitration ecosystem in terms of its efficacy and quality. Now, these functions include recognizing and grading arbitral institutions, promoting institutional arbitration, knowledge dissemination, and norm generation geared towards increasing the quality of the arbitration system as a whole. However, while reckoning with the great potential of any institution, one must also be mindful of the challenges it faces, as also past experiences, which would reveal the enormity of the task at hand. Now, the closest example which one may come across, of course, one without such an extensive statutory mandate, is of the erstwhile ICADR, which, while also styled as an institution to develop the arbitration ecosystem in the country, aside from being a mere arbitration center, is widely viewed as having been unable to achieve the former purpose, despite having possessed significant physical infrastructure. In this background, one must also reckon with the inherent bureaucratic red tape that any element of regulation entails, and how this can be reconciled with the system of arbitration, which prides itself in its flexibility and customizability. Now, several issues would therefore arise under the overall rubric of this normative tension, such as parameters for gauging performance of arbitral institutions, the necessity or the desirability of laying down standards for arbitration for arbitrators in the sense of, say, mandatory minimum qualifications, etc. We also need to engage with the potentiality in other more esoteric areas, such as promotion of arbitration in terms of knowledge dissemination, and for equipping potential practitioners with the requisite skills to further hone their craft and to ultimately result in the formation of an arbitration bar in itself. Now, these are all complex issues, and considering the importance of the role that the Arbitration Council is envisaged to play in the days ahead, issues which require extensive debate and deliberation. Now, for this purpose, we could not have asked for better speakers today than Honorable Justice Sanjay Kishan Kaul, Judge, Supreme Court of India, and Mr. Darius Khambata, Senior Advocate and former Additional Solicitor General of India. Now, Justice Kaul, with his long years on the bench at the High Court of Delhi, then subsequently as Chief Justice at the High Court of Punjab and Haryana and the High Court of Madras, and now at the Supreme Court of India, has had the opportunity to deal with a wide length and breadth of all kinds of matters under the rubric of arbitration law. Aside from having rendered several authoritative pronouncements dealing with arbitration law, he has also been vocal in various judgments in relation to what ails the system of arbitration in India, whether it be his professed disappointment at the inefficacy of pre-arbitration mechanisms such as dispute review boards in the Indian context, to be very specific, to his concern at the tendency to challenge each and every award as a matter of routine, Justice Call has seen and identified firsthand the areas of concern that need to be addressed in our system of arbitration. We are privileged to have him here with us. Now, Mr. Khambata, one of the foremost figures at the bar in the practice of arbitration law in the country today, brings with him decades of experience in the field. Aside from his private practice, he has also had significant experience on the other side in the context of a 34 petition, representing the government in his stints as Advocate General of the state of Maharashtra and later as an Additional Solicitor General of India. He is also a former Vice President of the LCIA Court and a current member of the SIAC Court. We couldn't have asked for someone with a more varied and rich experience from the bar in relation to issues surrounding arbitration as a system and international best practices in the context of the Indian legal environment. We welcome him here today. Now, I would request Mr. Shashank Garg to kickstart the discussion. Over to you, Shashank. Thank you.
Thank you so much, Amit. I think you have defined the four corners of the discussion today, because this is a very controversial topic, a topic that has been debated for last several months after the amendments have kicked in. However, this said part has not been notified, but it is, of course, of great interest not just to domestic practitioners, but also to international practitioners and institutions, because nobody has really understood what Arbitration Council of India is and what it is likely to do. So with such eminent experts, I think today we may get answers to some of those questions. Before I kickstart with the first question that we have for our panelists, just a housekeeping rule, I would request all the viewers, if they have any questions, to put it in the Q&A section, so that after the discussion on the questions that we have already received is over, and if there is time, we may, either me or Amit, take up some of those questions with the panelists. Okay, without any further delay, the first question for our panelists, sir, does the Arbitration Council of India in its present form in the Act replicate the essence and objective as envisaged for it by the high-level committee, which was chaired by Justice Sri Krishna? Justice Cole?
Shashank, to my mind, the fundamental problem which is arising is that from what Justice Sri Krishna envisaged and the Amendment Act, there is a difference in how this council will work, according to me. How Justice Sri Krishna's recommendation, the committee recommended that a more prominent role to the setting up of the system under the aegis of the judicial system. So, for example, a retired judge of the Supreme Court of India or a High Court with substantial experience was to be nominated by the Chief Justice of India. And an overseas arbitration practitioner having substantial knowledge and experience in international arbitration was to be nominated by the Attorney General of India. So, in my perspective, it had taken care of the expertise for nominating these people coming from the head of the judiciary and the head of the bar in the sense of the Attorney General. Now, if you see the amending act instead of thereof, we are talking about now the nomination or the appointment going to the central government in consultation. Okay, now it may sound a little innocuous, but it is not so innocuous to my mind. So what happens is the government keeps an element of control ultimately, and there is a consultation. Now you may have another debate whether it is concurrence or it is consultation or what is the ramification of it. Similarly, they talk about an academician having experience in research in the field of arbitration to be appointed by the central government in consultation with the chairperson. Now, how in the hierarchy it will work to my mind is, firstly, the appointment will be by central government, then that nominee in consultation, then the nominee itself will be in consultation, central government will appoint, and then the Secretary to the Government of India, Department of Expenditure, Ministry of Finance or representative not belong as a member ex officio. So, if I may use the word, it tends to change into a bureaucratic system. Of course, government support is required to manage the whole thing and the infrastructure issues and other factors. But there has to be a play where the experts manage it to give confidence. What is the ultimate objective? You want to encourage institutional arbitration. You want to bring it up as alternative centers to the the London Center, to the Singapore Center, which is doing well, to the Hong Kong Center. Given the scenario now, the moot point is, will this kind of a setup encourage people from outside to come here or not? I have some doubts whether this kind of a arrangement will be conducive to encouraging the center as a pioneering place. I would have much preferred that it is left as was recommended and given to manage to the experts rather than a bureaucratic system. Then we have to also look at from another point of view. See, we have been saying, and I think I've been saying that in India, unlike most countries, the government is a very large litigant. So whether it's the courts, municipal authorities, public authorities, infrastructure development authorities, the major chunk of litigation is coming from the government itself. Now, in that way of the matter, the role played by the government in setting it up becomes even more a classical case of the person who is a litigant in some way deciding how the system should be managed. That's a different matter. I feel that unfortunately, the government litigates from the highest to the lowest court till it gets a certificate from the Supreme Court. I've labeled them as certificate cases. Take it to the Supreme Court, get it dismissed, and then only implement something. And the irony is some of the infrastructure companies, and recently the newspapers have talked about the authorities dealing with road construction and road authorities. Every contract possibly goes into dispute, irrespective of whether the party is the Indian party or Korean party or Japanese party. And in a very uniform fashion, they keep losing from one tier to the other. At one stage, I had told the NHAI that, you have a very clean record before me. You've yet to succeed. So, given that scenario, I think it becomes a problem, and the exclusion of a foreign legal professional from the list of qualified to be an arbitrator also the problem. Though there is a recent notification now, just 2 days back, which has been issued, which may partly address this problem, which is arising from the schedule.
Thank you for your candid views, sir. Mr. Khambata, would you like to add?
I think Justice Kaul has put it very well. What was meant to be a facilitating and perhaps policy-making body, which was the role envisaged by the Sri Krishna Committee for the Council, with representation and viewpoints, including of international viewpoints and independent representation from the bar, has become more akin to the form that you might expect of a regulator. I'm not saying it is a regulator. The Act doesn't make it a regulator. But this is how you would set up a regulator. And I think Justice Kaul was right to point out the small but significant changes. Because there's a subtlety in those changes on who appoints, which can affect the entire color of an organization like this. There are equally small changes made in the duties and functions of the council. And if you see them and if you compare them to what the Sri Krishna Committee did, the Sri Krishna Committee actually has a paragraph saying that this council is not meant to be a regulator and it is only meant to evolve standards for grading of institutions. If you actually see the duties and functions, it first of all speaks of the operation and maintenance of uniform professional standards in respect of all matters relating to arbitration. Now, I don't know what that means. What does uniform professional standards in respect of arbitration mean? Qualifications for the arbitrators? Does it mean qualifications for the lawyers appearing? One doesn't know. Also, if you see the specifically enumerated functions, there are 2 or 3 which have been changed. The Sri Krishna Committee had given us a similar list. If you look carefully, there are some significant changes. So the Act has added small e to subsection 2 of 43D, which speaks of framing, reviewing, and updating norms to ensure satisfactory level of arbitration and conciliation. Again, one doesn't know what that means. Then I speaks of conducting of examination and training on various subjects relating to arbitration and conciliation. Now, if all this is in addition to the system as it operates today, then that's fine. But if this is a means of imposing some qualifications on arbitrators, then it will be a retrograde step, because the essence of arbitration is party autonomy. It is a judge appointed by the parties. The person may have no qualifications at all, but if the parties desire him, then he is the correct person to decide their disputes. In family disputes, particularly, you will have people who have no qualifications at all. Their only qualification is that they are a well-wisher of the family, but they are perfectly suited for that type of arbitration. So, of course, the 8th schedule, as Justice Kaul has pointed out, has just recently, few days ago, been deleted. But Section 43J, which set norms for accreditation, and it said that it will be on the basis of the 8th schedule, still remains. And 43J now says such accreditation and qualification as may be prescribed by regulations. So really, the 8th schedule has been taken out. We don't know what regulations will be brought in its place. So I think the character of the council has undergone a subtle but very significant change in the act, and it's not a good change. It will not encourage arbitration. It may discourage it, in fact. So we have to be cognizant of that. But that said, one has to accept that the government has listened. There was a lot of criticism when this amendment first came out, particularly of the 8th schedule. They have now removed the 8th schedule. Perhaps a little tweaking of the provisions concerning the Arbitration Council might also have been in order. It has not yet been notified. But other than being a policy-making body, and in which case I ask the question, do you really need such a body? But other than being a policy-making body, one hopes that it will not slide into the role of a regulator.
Right. Thank you, sir, for that enumeration of what is possibly the differences in terms of how this was conceptualized in the originating document and what is the kind of structure that is thought to be put in place right now. Now, being conscious of this, we obviously have to reckon with a wider question, and which is that considering the contemporary status of the arbitration ecosystem in India, what are the kind of wider aims which this institution, this proposed institution, should seek to actually effectuate, as also what are the potential pitfalls which the management of this proposed institution should be conscious of while charting a path for the future, particularly taking into account our past experience, as also the international best practices in this regard.
You would like me to respond, Amit?
Yes, Justice Kaul, kindly, sir.
Okay, I mean, picking up from what Darai said earlier. See, let's look at what is so particular about the ACI. Now, the whole concept was that you will set up this as perceived to be a more unique institution to issue guidelines or providing recommendations to arbitral institutions and accredit them. So you are wanting to maintain a party autonomy concept, which to my mind is very important in the Indian context. It flows from the first question because a lot of Indian business are family businesses. So one of the important aspects that I mentioned was that it's not that a highly qualified legal person alone can settle disputes. It is the faith which is there in a particular person, often maybe in an elder person, which can also sort out these disputes. So if you talk about the party autonomy, and that's the whole concept, I think, of arbitration, of choosing your own judge to decide with consent your case, the very fundamental role which this was to be performed seems to have been deviated from, respectfully, I would say. And the aim seems to be to give another some kind of a semi-department of the government, and my apprehension is same as the rest, that it should not slip into a regulatory body trying to control. The very purpose would get lost, because as I understand, in whether it's Hong Kong, Singapore, London, Paris, an institution in this fashion doesn't exist. Maybe the systems are better set there, it is there. The idea was to set up a system like this to encourage arbitration. So it was not another arbitration council to take parallelly in that sense, whose job is to carry out arbitration, but to to issue norms and guidelines to encourage a culture of arbitration. Now, this has to be, as I said, in the backdrop also importantly of the Indian arbitration landscape. And it was a nascent stage of development. What are the main balancing of principles if you want to have an ACI which will have to balance this principle of party autonomy? One of the main fundamental issue is how do you maintain independence? And that's why Justice Sri Krishna's committee envisaged an aggregating body comprising representatives of stakeholders, so arbitrators, arbitration institutions, free from government involvement. That's the whole, which is not giving me a very comfortable feeling, is that the whole concept of having something which is free from government involvement is now today, I think, completely a government involved institution, as envisaged, unless further dilution, as he says, takes place, like happened a couple of days back. And the authority to guide the functions of the ACI, etc., through central government is what had fueled the criticism. Now, bearing this in mind, the tendency of parties in multiplicity of these arbitration proceedings and the government involvement, which I mentioned earlier, the conflict of interest principle is one of the things which will have to be addressed. And I think that can only be addressed by slowly turning towards back to the principles which the Justice Sri Krishna Committee had envisaged. Second aspect is transparency. It has been, the objective is to have an institution acting in a very transparent manner and embody the principles of a good arbitration. That is the principle on which accreditation has to be awarded to the arbitral institutions, as spelled out in 2019 amendment. The standards of these accreditation are still a little nebulous, and especially in view of the notification the last few days ago. And so there should be, when they're devised, I would say they should be published in public domain. And the grading process should also be transparent. So what is happening is, after the amendment to the Act, we will have to go through another process of how it has to be run. And how it has to be run has to be again put in a public domain and suggestions invited. Then only I feel it can be a meaningful exercise. The third aspect I would like to emphasize is avoiding an over-regulation. Again, something that I mentioned in a different way. That the Sri Krishna Committee clearly emphasized that accreditation should by no means morph into a regulatory body. And it was mindful of not transcending into a body which seeks to relegate the day-to-day functioning and capture that issue. That is, it's not giving a comfortable feeling, I feel, on those very fundamental issues which needs to be sorted out. Details later. And therefore, the rule of granting maximum party autonomy and choices to make an arbitration an attractive place would require a principle of, I think, self-restraint by the ACI, a better setting up of how it will work and the accreditation principles, and putting them in public domain to invite suggestions before I think it can give a meaningful contribution.
Thank you, sir. May I also ask Mr. Khambata, in terms of your experience with a lot of international institutions, though of course the parallel may not be exact in that sense, what do you believe in terms of international best practices that the proposed ACI would be well advised to follow in terms of effectuating its mandate, sir?
I think the ACI should focus on one of its duties, which is encouraging institutional arbitration. Because having seen how arbitration is practiced abroad and having seen how it is practiced within India, I can see a great value in a good arbitral institution. Now, what is a good arbitral institution also is sometimes a subjective question. But over a period of years, certain institutions have acquired a reputation. I don't only mean international. Take institutions even within India. You have the Delhi High Court Center. You have the Nani Palkhiwala Center. You have the MCIA and the IMC in Bombay. These are all institutions that have acquired a reputation by reason of their best practices. They've not been conferred with any grading or certificate. They have acquired that reputation because the market goes to them, because the market has confidence. That's why, for example, SIAC, which is really a very new institution. It was, I think, only 1995 or so it was formed. But it is shot to being the number 2, or perhaps this year even the number 1 arbitral institution in the world. And a huge part of its work comes from India. I think the figures have been anything between 35 and 40% annually. And that is because Indian parties have trust and confidence in it as an institution. They don't go because it carries a certificate of the Singapore government. That doesn't impress a party. So it's the record. So the encouragement of institutions should be by way of guidelines, by way of facilitating factors, perhaps even some hardware, in the sense that all over India, and we tend to think only of the metro cities, but there is huge amounts of arbitration even in the smaller towns and cities, where there are no proper facilities for arbitration. So perhaps suggestions could be made via the council that the government set up arbitration centers where people are given facilities. They don't have to pay for hotels, much less 5-star hotels. They can get an arbitration center with basic facilities. And those facilities would improve over time, where they can conduct arbitrations. The other area where the council could make policy is technology. It is amazing what technology is being used today in international arbitration, even before COVID. I'm not just talking about remote platforms. I'm talking about real-time transcription, which we have never had, but which according to me is basic. You have to have real-time transcription to have a proper record of the arbitration and to make it go faster. It's actually cost saving, though it's usually denigrated as being something that increases the expense. Actually, if you come to think of it, given lawyers' fees today, it saves in cost because it reduces the time. There are many other things. I once did an arbitration where they had something called Opus Magnum. It's a recognized institution. It was a very fact-heavy arbitration. There were some 50, 60 volumes. So it was impossible to physically use many of them. They had a technician sitting in the room, and we all had computer screens in front of us. And all one had to do was mention the volume number and the document number, and that would appear immediately on everybody's screens. You didn't have to do anything. I mean, someone like me, I'm not tech savvy. So I would go fumbling if I had to pull up the document on my own. But this just made it so much easier. So it can look into technology, suggest technologies that are relevant to our system. There are many things a council can do if it is an advisory or policy-making body, no doubt about that. But the danger is it shouldn't slip into, as Justice calls, as a government department. Then that will be a problem.
Thank you, Mr. Kambata. As Justice Kaul pointed out, that all the famous jurisdictions which have prominent institutions such as SIAC, ICC, LCIA, HKIC, etc., nobody has had anything like Arbitration Council of India. One jurisdiction which might have a similar setup, or rather a prominent regulator, is actually Russia. And I'm sure in terms of arbitration jurisprudence, nobody wants to follow the footsteps of Russia. So moving forward, the next question for the panelists is that in relation to accreditation and grading of arbitral institution, what are the parameters that Arbitration Council of India should evolve, aside from the obvious criteria such as infrastructure, management of caseload, etc.? Can we start with Mr. Kambata, given your experience with institutions?
I have some experience, limited, with institutions, but I don't have experience of how to grade institutions. As I said, the best grading is from the marketplace. It's from litigants. But of course, I think the fundamental foundation of a good institution are its rules. And not just basic arbitration rules, but rules with respect to different aspects of arbitration. So you could have conflict of interest rules, you could have rules on evidence, you could have rules on the actual procedure. You could have, as currently institutions are coming out with, remote hearing rules. It's sometimes a misnomer to think that arbitration is without rules, unfettered, and completely at the discretion of arbitrators. In fact, that is not so. Internationally, there is now a huge body of what you could call an international law of practice and procedure. You have the IBA coming out with all sorts of guidelines, which are very useful. And you have institutions, including the Chartered Institute of Arbitrators, coming out with procedural guidelines. All of this is to ensure that the arbitration proceeds in a recognizable, predictable manner and with complete fairness to both sides, because the strict rules of evidence and law would not apply. Now, a good institution will keep on evolving its rules. It will keep on reacting. For example, SIAC came out with its virtual hearing rules within a few months of the pandemic, and rules for other types of procedures, etc. So rules are very important. Second is confidence in the registry or the office of the registrar or the secretary general. Sometimes in some institutions, I know from India, we didn't have good experiences. I'll just leave it at that. Whereas, again, an institution like SIAC, I think most people have had very fine experiences. They've seen a fairness in the office, there's been a responsiveness, and that has also helped. Then you set up a court, for example, which is really arbitration practitioners from all over the world. It's an advisory body. It doesn't actually do very much, except in the case of one or two institutions where it sees awards. But they give you ideas, they give you suggestions. There's a lot of debate. So you have to build up a whole infrastructure and institution like that. Now, I'm not quite sure how you would grade it, because, I see your question. But, for example, the LCIA, you may not realize this, which is a very fine institution. It has a very small office. It has no great infrastructure. It's just the institution. So it's not that arbitration institutions have to actually set up an arbitration center. Even SIAC, the center in Singapore is set up by the Singapore government. It is Maxwell Chambers. SIAC has only an office. So the two are different. So really it's the procedure, the regulations, how it is run, whether it's perceived to be fair, transparent, open, its responsiveness. And these are things that are built up over time. So I'm not sure how the council will start grading a new institution, for example. Something that has been running for some time, it can grade, but otherwise it would become very difficult. And these are possibly the only objective markers one can set.
Justice Call, say your views.
We were largely in a system of ad hoc arbitration. So what is wrong with that? What went wrong with that was that it became an indeterminate kind of an exercise. A delay was manifest in it. It was uncontrolled in many manners, and therefore the whole concept of what has been slowly internationally accepted is the institutionalized arbitration regime. It is with this objective and to encourage that the SAI has to play a role. Now, as he rightly said, institutions build their own reputations. So he gave an example of the Delhi Center, which is not that old. It was set up maybe 10 years ago. I remember Justice Shah was the Chief Justice at that time, and some involvement we had when it was made. When we went to Chennai, in Chandigarh, I remember as Chief Justice setting up an arbitration center. It was one of the old court buildings which was lying unused, and we devised that and restructured it. So only the whole ground floor was restructured by changing the rooms of a building which was lying unused, and possibly it had greater space because there were big rooms which were there, so it could do. Similarly, in Chennai, the administrative building block, we put one floor for it. And we reached a stage where it was difficult to accommodate all the arbitrations which wanted to be held in the court annexed arbitration center in Chennai. Then we had a discussion with the Palkiwala Center in Chennai, and they had, for example, space. So collaborative effort took place where the arbitration could be whenever space is short. They said we'll more than welcome. So their space also gets utilized. So we were doing some arbitrations there and some arbitration in the Palkiwala center's space. Of course, the rules were governed by depending under which AGs it was being held. So this kind of a collaborative effort also works. So ultimately, when you are saying, I agree with the Raj. I don't know how will you give a plus, A, B plus. I mean, what kind of a grading will you do? He has also mentioned, and I want to take from, for example, the use of technology. So technology has is one aspect only of the whole thing. Yes, how quickly you take down records is a factor. There are systems there which are prevalent abroad, which have been incorporated in arbitration or immediately transcribing it. The Delhi Center is a good example where it's extremely tech savvy in terms of the facility. So one parameter can be the kind of facility is offered, the stenographer assistance which is offered immediately, so that you can have a walk-in place. The only problem is there are a lot of these, as I come to know, people setting up arbitration centers as commercial ventures. I don't know whether it's just making it very nice and savvy place, or is it also looking to the other software part of it. Rules is something which that I emphasize again. I'll see. I've always felt what aids our arbitration system often is the mindset of a civil procedure code. So everything must go by the CPC. With due respect, the arbitrators also sit with that intent, and the lawyers also want to proceed in that direction. So you will file pleadings, then file frame issues, do this, that, the other. These are all important parameters. What kind of rules are set up to expedite the process and make it good and transparent? What kind of infrastructure would facilitate the arbitration? Is it technologically savvy to be able to deal with the scenario which is there? These would all, I think, be parameters to determine it. The deterrent which has been to some extent, which was the parameter also, I think, is that if you read section 43I and 43J, 43I tries to set forth some norms, and 43J has been amended by this 4th of November notification now. So I think we're still in a little fluid state, I would say. So nobody's made up his mind. So you after a lot of thought process of an expert committee, you get a recommendation. Then you make changes to that recommendations and enact something. Then you realize the changes you made are creating a problem. So you take back some changes. Then why not do it? A model to my mind should have been what was envisaged by the Justice Krishna Committee. If there was a specific reason to tweak some part of it, in view of the suggestions received thereafter, that should have been done. Instead of using to tweak the system with the modified Sri Krishna report, at the behest of, I don't think the best of experts who would be doing it, this legislative exercise. So I think any accreditation which has to take place will have to keep these factors in mind. But institutions will grow by their reputation, and that's important, I think. Otherwise, people will feel that you go where the services are best. Okay, that's how it is. In a private enterprise, that is how it will work. So some institutions set up an arbitration centers will last, I believe. Some private institutions which are purely non-thought of commercial ventures will die out, and it'll take a little time to stabilize, is what I think.
So there's some very important takeaways from what Mr. Khambata and you have stated. And I would just like to do a quick follow-up question on this. And also when Mr. Khambata stated the significance of setting up of a court in an arbitral institution like SIAC court and ICC court, one of the major functions that I think is of a court is to also decide a challenge to an arbitrator, which to a great extent adds to the accountability and credibility. So the follow-up that I have is the present status of Arbitration Council of India and the objectives as per the Act. I would like to understand from both of you why ICC, SIAC, or a reputed institution would like to be graded. Because the benefit of grading, as I see from the Act, is only that you, as a graded institution, may be designated by the High Court or Supreme Court, as the case may be, for appointment of an arbitrator. So the benefit you're deriving after getting graded is only that you could become an institution who could be an appointing authority in the cases where Supreme Court or the High Court feels that they would like to delegate this power to you. Now, they are not going to administer the arbitration. That point is not clear. Nowhere it has been stated that just by appointing an arbitrator, it would take the color of an institutional arbitration. Parties may still want to go ahead with an ad hoc arbitration, and courts may not be able to override that party autonomy status. So why would any reputed institution would be interested in getting graded and then become an appointing authority, which may not really be commercially viable for them and take all the pains of going through the rigors of Arbitration Council of India and the procedures that they will set up? Mr. Khambata, this is called, any views on this?
Yes, Mr. Khambata, you are on the field, sir.
No, I think the idea of that, as you rightly said, is under Section 11. A court can allow a designated arbitral institution to appoint, and the Act now provides that that can be only such institution which has been graded. So that is a basic safeguard, that it won't be any institution. It has to undergo some grading. However, I tend to agree with you that the discretion of the court should not be taken away, because an institution like LCI or ICC may not want to be graded. Our court is familiar with their reputation. There's no reason why a court should not even allow them to appoint in a given case. The idea of a designated institution appointing rather than a court is sometimes a court would feel, in a technical matter or in a matter requiring some special expertise, it may not be aware of who are the available arbitrators in the field and how well they've done, which an institution may be aware of. And that's the reason why under Section 11, power is given to the court to delegate that function to a designated institution. So I think as long as the Act is only facilitated, so it can grade institutions, but it should not exclude institutions who are not graded. And that was, in fact, the fallacy in the 8th schedule. The 8th schedule said you shall not be eligible to be appointed as arbitrator unless you have the following qualifications, which 43J never said. So now we are back to a situation where there may be accreditation of arbitrators, but that doesn't mean that anyone who's not accredited doesn't have the right under law to be appointed arbitrator. And that's a nice balance to keep. Because I don't think it's fair also, that you should have to accredit, for example, retired judges. Why should they have to go through any accreditation, even if they don't participate in it? I don't see why an institution should be accrediting them. And that's not the way it's done in any institution. So as long as there is a pool of accredited arbitrators, which a court knows has some standard because they've been accredited, which it can choose from, or it can also choose a non-accredited arbitrator, and you leave that to the best judgment of the court. So if you keep that balance, it's fine. But the moment you say only accredited arbitrators or arbitrators with only these qualifications, then I think you run into a problem.
Ultimately, what is the objective of this accreditation? Let us look at this. On the lighter side, can you grade the senior counsels? Can you grade lawyers? Can you grade judges? No. So what are we talking about? We are only saying that it provides the kind of facility and a software which will facilitate arbitration. And the software I look to it is, are there a panel of arbitrators in which the litigant and the lawyers have faith, who work in association with that arbitration center? Now, if the idea of accreditation is only to see that the basic facilities in terms of the infrastructure, the probity of maintaining records, the facilitation of technology, factors which Raj just talked about, are there, I can understand that, look, you will say that this meets for all these standards. But the problem is going to be ultimately that the arbitration is conducted by the arbitrator. He is the chosen judge. That being the position, it is ultimately the arbitrators and litigants and lawyers who would feel comfortable in the management of that arbitration by that particular center. Center will manage the arbitration. Similarly, it's not that every dispute will go to court. People there can be people who are willing to go agree on an arbitrator themselves, but would like to be governed by a particular rule or norm of an arbitration center. Now, if the process and the procedure is well drawn up, and the arbitration center requires the reputation of making sure that things are adhered to, that there are no delays, that there is a probity in the process, that arbitration center will acquire its own reputation. It's correct. Why should some of the well-established foreign centers ask for gradation? It's ultimately the faith. I think the only purpose of gradation, which I can find some sense, is that there are new centers which have been set up or which are likely to be set up, and to ensure that they have a proper process and a proper facilities and a proper panel of arbitrators, you can judge them on that basis. I don't know whether gradation can do really something more than that, and some of them may not be even willing, I feel, to get into this area, and which will, if the good ones don't get into it, ultimately the gradation is valuable if the good ones are also there. If they are not in it, then it will to some extent become a less meaningful exercise.
I mean, I won't be surprised if Government of India mandates the PSUs to only put clauses of those institutions which have been accredited and graded by Arbitration Council of India in future. That could actually become a game changer, because there are a lot of big PSU contracts which have ICC, CAC clauses, especially when they contract with foreign contractors. So that possibly could be one way to arm twist these foreign institutions to also get themselves graded. Just a thought, maybe.
You may be right. You may be right, but I don't know how far this arm twisting works. You are looking to inviting capital. You are looking to creating infrastructure. You want people to participate in economic activity. Now, if somebody is willing to do that, you can't say that, look, I want you to come and encourage economic activity, but if a dispute crops up, I'm going to twist your arm and say that this is the method of doing so. I don't know really how it will work.
Right. So I think that way, I think in terms of this trend towards attracting investments, even in terms of the FIDIC contracts, the only reason why a lot of the PSUs moved away from the traditional contract and to the FIDIC contract in construction contracts was this reason, that a lot of the foreign funding in terms of ADB loans, etc., were contingent on the fact that your contracts must prescribe to an international best standard. So I guess in that sense also, probably the Arbitration Council of India will also have to bear this in mind, that it does not compromise in any way the access to the international best institutions while it is undertaking this grading mechanism. Now, sir, I want to get onto a slightly controversial and touchy area of discussion. It's again taking off from what Justice Kaul mentioned in terms of the faith ultimately dictating the strength of the arbitration mechanism, particularly faith in terms not only of litigants, but also the faith of the traditional court system in terms of what arbitration represents. Now, in this backdrop, sir, one of the significant criticisms or the problems which we faced is in relation to, say, a lack of confidence in terms of the quality of the arbitral awards, and possibly also in certain cases in terms of the qualifications of the arbitrators who are actually writing these awards. So specifically from that perspective, what are the specific steps that the ACI can contemplate in terms of improving the quality of arbitrators as also arbitral awards, sir? This is called, sir, having seen so many of these awards in Section 34 jurisdiction, what do you think are the areas of concern that we need to take a look at?
I appreciate what you are flagging, because it is my personal belief that if at all, the interventions of the court should not be at a post-arbitration stage, but it should be to see how the arbitration process is put in motion. Once the arbitrator you have the faith in it, the thing should proceed. Now, one function I think of the commission can be to encourage a discourse, and I would not use the word training, but improving expertise of arbitrators in performing the task. We must keep in mind, we have been talking about that arbitrators should not be confined to only people who, in that sense, are strictly legal persons only. So let's talk about if we are saying upon arbitration, which is say a family arbitration. It may be some from family elder as an example, which was given by the rise. But yet people, if he has to act in that manner, he must understand some basic concepts of how the arbitration is to be facilitated. Now, when that is with the institution, the norms of the institutions, the rules of the institution are itself a guiding factor. So he knows that this is the broad procedure by which, and it should not be complex or detailed going into the nitty-gritty like a civil procedure code. But the best principles of what need to be adhered to, if they form part of the rules, these are the guiding principles for persons who may not be of the legal field. Second can be there may be people who are not people of law but who would like to do more work in this area. Similarly, you can have facilities for improving the skills. We've been talking this in mediation for a long time. We improve the skills of the mediators. So they go through a training. I don't know why we should hesitate at all. And in providing better arbitrators through a process of interaction, experts talking to them, maybe conferences, maybe seminars on these subjects. That's the role, an academic role, which this commission can, I think, certainly play. So far as the legal people operating as arbitrators are concerned, I would presume they know the law, but not every judge can be a good arbitrator. Not every good lawyer can be necessarily a good judge. The reverse is also true. Equally, judges may not be that good lawyers at a later stage. So I'm not attributing any motives, but I'm just saying that people devise their own abilities, and it's a question of process of learning. Some of them continue to be in a process of learning. The judge can't, though he has to maintain his independence in certain basic requisites similar to a judge. But I think the commercial litigation, especially, and the commercial arbitration requires a more proactive and less dominating role, in a sense, in trying to come to terms with what the person has to do. So, in a way, there can be again academic discussions for judges to facilitate them how the arbitration should proceed after they retire. Go through some unlearning process and some learning process both for improving their skills. And I think all this is we are today in an age where there's a constant process of learning. The areas of litigation are changing. The complexity of cases are going very different. It's very different if I look back 2 decades of my judgeship and see what was the prime area of litigation when I was at the bar. It's completely different from today. So we've dealt with as judges very differently. And the pace is not going to be less. The pace is going to increase. Look at things like people are talking in terms of now businesses which will no more remain the primary fields. Artificial intelligence comes in. AI will come in. What kind of businesses will become irrelevant? What will become more relevant with AI coming in will throw its own challenges when disputes arise from those businesses. Second aspect I would say is, can AI, to what extent can it be used? We are talking about using AI in some parts of court. To what extent can we use it in arbitration proceedings? I'm not an expert in these fields, but these are discussions which will have to take place. And the pace of change is very, very fast. So you'll have to get people who are experts in this field to assist the centers in managing their arbitration centers in a manner which will gear to the new areas of litigation and new technology which will come in, and how to manage that and come up with better solutions.
Right. Thank you, sir, for that broad overview in terms of what really we need to do. Now, sir, Mr. Khambata, what are the kind of measures which you think the ACI can put in place or require arbitral institutions to put in place in terms of, say, a minimum quality control in terms of the awards that are passed under the...
Justice Call has hit the nail on the head, because there are international best practices, and I don't say this in an unqualified way. There are some international practices which one may not agree with. So there is need to evolve the best practices in maybe even hybrid practices, and to actually educate people about them. And we as lawyers and as judges we are constantly learning. That's one thing about our profession. No one can sit back and say, I know everything. So there's no harm in learning, and you can learn via seminars, via courses. There's, of course, the Judicial Academy. This is where the Arbitration Council can come into play. I've always maintained, and I still maintained, and I've said it publicly for years, that I truly believe that an Indian lawyer is second to none in his practice, and for various reasons. I'm just generalizing just now, but there are good reasons for this. However, sometimes we lag behind in certain elements of how we package up arguments, how the presentation is, how we should keep within time limits. We are not as adept at the written word as we are at the oral word. This is how international litigation and arbitration has moved. Now, I think that one of the functions of the Arbitration Council is to bring that educative factor into our arbitration practice. Obviously, it can't be done by setting up a school of law or a college, because most of the people in the field are not going to be at that level. They're going to be at different levels of practice. Therefore, you need an arbitration council to assist in that. I think there are huge areas, not only of technology, but of best practices that can be introduced. I've already seen, and this is purely by accident or by pandemic, that our practices during the pandemic have exponentially increased in favor of the written note and written submission. So many lawyers now are preparing that for the court because they realize that it's not possible to argue in a traditional way when you're arguing into a screen and you have a limited time frame. Then how to prepare written submissions, how to put forth an argument. There are many nuanced areas of practice. Equally, there are areas even of how to conduct an arbitration, procedural matters, writing of awards. As Justice Call rightly said, the CPC mentality would have to go. Now, one of the good templates which most international arbitrators are the IBA rules of evidence. And they're very simple. They're clear, they're simple. The basic rule there is that every document is to be admitted unless there is a specific objection raised to that document by the other side and on certain specific grounds, not just on any ground. Many of you, of course, are familiar with the Redfern-Hunter schedule. So when there is an application for production of documents, it's even before the pandemic, was all done remotely. There is a particular chart that is to be prepared. In the first column, you set out your ground for application. The second column is for the other side to put its objection. The third column is for you to respond to the objection. And often arbitrators used to decide that without an oral hearing or a very short remote oral hearing, even before the pandemic. So there are many ways in which all these methods can be brought into our practice. So there is a huge area there where I think the Arbitration Council can improve standards and really uncoil or unleash the full potential of Indian arbitrators and Indian lawyers in the field of arbitration.
Right. Thank you, sir. I think this is something which we all look forward to, at least in the future, in terms of some sort of ameliorative guidance from the ACI, so that the overall quality, in fact, in terms of adjudication, can definitely be improved. Thank you, sir.
I think with that background, I must state that many of our arbitrators are well equipped and follow a lot of international best practices and standards. However, that is most seen when they are doing international arbitrations or under the aegis of international institutions. And the same set of arbitrators, when they're doing the domestic arbitrations or ad hoc arbitrations, seem to transform back into the classic way of doing
But
this.
Shashank, sorry to say this, but that's even more true of us as lawyers.
That's true.
We adopt a completely different approach in an international arbitration or domestic arbitration. So,
Shashank, I'll say this. See, some way, and I'll say of both judges and lawyers, we lose focus of that the beauty is in the brevity of everything which we are doing. When I say the CPC mentality and the traditional way, people want to argue ad infinitum. They say unless there is such a argument, and the courts also adopt that, and arbitrators adopt that. Now, it is far more difficult, I always believe, to say something in a brief manner and to write something in a brief manner, both, because it requires a greater clarity of mind to be able to do that. And if we move towards that system, as you say, of both the arbitrators and the lawyers, and being better, let me say, equipped with this technology now in terms of better practice during this. We have realized in court proceedings also, people file synopsis, and we keep saying it should not be another another volume of it, but the idea is to help in assisting writing a judgment. Similarly, the note should be to help the arbitrator in arriving at a conclusion. Interestingly, one of the examples that I gave was that he said technology permitted a person to be engaged, and when the magnum opus was there to turn to a relevant page or turn to the relevant listing instead of going through it. I can share an example which I followed. I've been at least operating court from my home. So one issue was people send list of books, and then the issue was of getting those books from Supreme Court, and with the pandemic and its all qualifications and problems. So a device which was I found very convenient was to put one of my law clerks in the chamber at a distance, and he sits with a laptop. That's all. I don't call for any books. I don't call for any bare acts. I don't call for anything. Whenever something is cited, these people are quick enough. They immediately take it out and show it to me. So I'm for almost now 3 months. I'm seeing those judgments on the laptop. I'm seeing the bare acts on the laptop, and those assistance is working well. So it's similar from what he was saying. One other issue I'd like to flag also is that the ASCI has also been given the mandate to collate arbitration awards. Now, I'll put a caveat there. I don't know whether we'll discuss this issue further, but I want to flag and give a caveat to it. There is, I think there's a problem if we say that every award will be made public in a sense. It's the same thing, of course, in a lesser, the mediation award is different. We opposed it that you can't. But there may be cases of family disputes and other where those people may not be interested in everybody knowing what the award is. And as I understand, when there is norms elsewhere also where it is not that every award has to be made public in that sense. So if we are choosing the principle of party autonomy and party choice in arbitrators, we must also give that party autonomy or party choice to the parties to decide whether they would like to bring their dispute in public domain, having decided to go through an arbitration, and that material to be available, or they say no, just keep it in a sealed cover or something, or whatever process there is which is in the we don't want that to be made public. We have settled our dispute. That's one other aspect I think which will have to be addressed. And I was telling, SIAC was being mentioned, but I'm informed that SIAC 2, as recently as 2016, made the consent of parties in tribunal mandatory before approving publication of an award.
Yes.
So if that is the principle, I think something on that line can be looked into. I'm told Hong Kong is a little different, but in the same way, they say, okay, unless you object to take, then we can publish it. So even in creating a database of the awards which are rendered, this aspect in creating the database, which is the work also of the council, will have to be with this caveat that the consent of the parties has to be there, or even sometimes if you think it's an important issue decided, maybe the parties may opt for a redaction and say, okay, we don't want the whole thing to be there, but only make available the redacted portion. I just think that this will be another aspect, I think, which will need to be addressed.
Sir, I think on the point of confidentiality, in spite of all the caveats and all the debate on confidentiality, we see all awards, come what may, of any institution, whether institution publishes them or not, GAR or the press within no time would have all the necessary details from the winning side and would publish all of them. So I think confidentiality has really become a great challenge if parties really want to keep it confidential. I don't know what mechanism is available.
Well, you can maybe, I'm just thinking aloud, maybe at the stage of conclusion of arbitration, this can be decided. And I'm sure if the arbitrator says party, it is agreed parties will not disclose it, let's say, it'll be at least an ankush, restraint on the parties. I mean, on one hand, we say privacy is a constitutional right, and then certainly what happens to your litigation has to be recognized as something which is between the parties. Of course, it's a challenge. I agree with the challenge because the succeeding party always has a tendency to, tom-tom, but there are cases where the dispute after resolution, even the succeeding parties may not want everybody to know what they were really settling. So it will work both ways.
So coming back to the next question that we have, in the light of the recent amendment that has taken place, repealment of Schedule 8, so what should be the new standards for accrediting arbitrators? Should it be a hard qualifying test, or should it be more soft skill based approach where, for example, CIR, they have different grades of education that they have, and as soon as you pass a grade, you become a member, and then another grade is fellow. So should there be a education and training related accreditation, or should it be a qualifying test, more so to do with professionals who are not lawyers? Because we see a lot of engineers, a lot of other technical experts who decide very, very critical and important issues, and they may not have the know-how of how to decide these issues in the right format that the Arbitration Act envisages.
I would always weigh in favor of a soft skill rather than a hard exam. Let's understand what is for every exam we create an exam cracking methodology. That's all. Are we creating? There's a larger debate, of course. I have graved out. Are we creating better engineers, better lawyers by the system of competitive examination we have by in a really a rote system? So ultimately, that's only a small part of it. I think the greatest challenge is to see that, which is by conduct, what is the probity of a arbitrator? And let me say, frankly, this is a concern, especially where technical members are involved who have been part of the government establishment. It's a great irony, I used to find, that the engineering department of different public bodies would like their retired officer to be earlier, they used to say, be appointed an arbitrator. And every award would then get challenged because they would say that the award has gone against them for whatever reason. So I would put a good checkup on probity issue as a very important thing, because when you see the chosen judge, he is the judge. He must administer with an even hand. Now, of course, some part of it will come with reputation, and if there are discrepancies found, there can be de-empanelments, etc. But making hard rules for law knowledge, I don't think will serve the purpose. Yes, he should have the capacity to understand the legal nuances, but often you will find in a panel, the technical member and the legal members are together, sit together, and the object of that is that somebody understands the technology better and understands the engineering issues better, and somebody else understands the legal issues better. So if a panel of arbitrators has one technical member, that subserves the purpose.
Mr. Kambata, do you?
I entirely agree. There has to be a soft standard, and that standard has to be fixed by each institution. So there will be different standards and different levels, because if the statute fixes a standard, then you are effectively excluding or eliminating some people who might be very well qualified in the general sense to be arbitrators, but without the basic minimum threshold qualifications that the statute provides. So you can't have something like the 8th schedule that says, unless you have these qualifications, you're not entitled to be appointed arbitrator. What you can say is each institution must set certain minimum standards, but those will always be soft standards, because an institution also recognizes that there will be various arbitrations. The classic example is family disputes, and as Justice Kaul rightly noted, in India you have so many family businesses and companies where the person may not even have a degree, but he may be an elder, he may be someone respected. So it would be very, very unfortunate if the act excluded anybody. Short of course, it can't be a minor. It has to be, some basic level, but those are soft. Those are very soft qualifications.
See, also I feel in an era of expertise, possibly I'm not saying now, you may have arbitration centers coming up, which will claim accreditation and which may be industry specific also, or industry specific. So similarity of industries. So suppose there are high tech industries, maybe some tribunal caters to those nature of industries which are there. And therefore, the expertise required for an arbitrator would may be very different there than a very legalistic view. So we can't obviate the possibilities of arbitration centers gearing. Like you have today also, there are certain businesses or industries or industrial monitoring agencies which provide for arbitration as a methodology. So those are people which is industry or industry specific. Therefore, how can you have hard and fast rules applying across it? For this kind of a thing, as that I said, there may be some other requirements. You have to sort this thing, it may be specific to that arbitration center, which may be catering to a particular requirement.
Right, sir. So just taking off from what Justice Kaul mentioned in terms of the wide range of disputes which ultimately end up before an arbitral tribunal. Now, of course, I'm aware that there is a lot of, let's say, debate in terms of whether we are witnessing excessive precedent being generated within the legal system. But considering the fact that ultimately a lot of arbitral tribunals do deal with cutting edge issues such as commercial law, infrastructure, etc., with, of course, operating within the parameters of confidentiality, should the ACI contemplate putting in place an institutional mechanism to make this body of work available to everyone in the legal fraternity, purely in terms of an exposition of law, say on some of these subject matters, so that it is the fraternity as a whole is better served within the overall rubric of maintaining a repository of awards, sir. So what would be your views on this, sir, in terms of going forward?
My short answer would be yes. Obviously, this is one of the areas which can be addressed, but the concern, as I said, was that maybe some principle that those people don't want it in public domain, and they may claim a redaction except on principles of law. Second methodology can be, okay, it has laid down it's like a note. So somebody prepares a note on the principle of law. It has nothing to do with the facts, but what has been laid down. So you can have more detailed ones, awards themselves, or you can have redacted portions of an award, or you can have principles laid down in the award. Over the last one, nobody can object to it. So that can certainly be done. So between these three categories, I think, as I can think of now, almost the entire material generated and the expertise which has been utilized can be available for the others. Of course, not to become. I always feel we are overweight with precedents. Actually, everything is a precedent. You produce volumes and volumes of journals. They're only meant for subscription. That's all.
No, so in that regard, I remember Lordships had in a judgment at the Delhi High Court, in fact, mentioned this aspect about how now at the click of a button, it's so easy to generate precedent to refer before a judge, and how therefore it becomes more of an obstruction in terms of arriving at a correct conclusion rather than being a guide or a tool for a judge in terms of adjudicating.
I still throw back the volume at the lawyer and say, don't give me these volumes.
Correct.
So, Mr. Khambata, sir, in terms of,
I don't believe that awards can or should ever become precedent. I think that is a function that has to be left to courts with trained judicial minds, judges who have had judicial careers. I think that there is a safety in that, and there is a certain sanctity in a precedent which should be kept that way. And I agree with Justice Kaul, you can't have a plethora of precedents on all. There's no harm in making awards public if the parties agree and if the tribunal agrees, because there's a confidentiality provision now. It's introduced in terms of 42A in the Act itself. So to give in sort of cutting edge areas of law, you could give an indication of how another tribunal has approached it. To that extent, it's useful, but it can never be of precedent value. I know that under ICSID, the Investment Treaty Arbitration Convention, to which we are not parties, so it's a separate convention from the New York Convention, awards are always published. So there is a fair amount of citation of other awards before exit tribunals. But that's a totally different system of law. That's a system of law that operates internationally, not circumscribed by any national system. So if you're under the New York Convention or you're under UNCITRAL model, which we've adopted for our act, an award is an award. It has a lot of respect, a lot of persuasive value, but it can never take the place of judicial precedent. That's at least my belief.
It is actually a facilitator sometimes for the arbitrators as to how a different arbitral tribunal
Correct.
handle a particular aspect. That's the only utility.
Absolutely.
Very well. I think we may not have enough time for all the questions, but I will take one last question from Mr. Ganesh Chandru. Mr. Chandru is asking, should the proposed Part 1A dealing with Arbitration Council of India be replaced with something which is drafted after consultation with stakeholders? Specifically, should the proposed grading of arbitral institutions be scrapped? I think we have debated this enough, but a final recommendation from the panelists, should it be scrapped? Should it be tweaked? Should there be a fresh consultation in this regard, or what we have is enough? Final word from both the panelists on that, sir.
We have debated at the initial stage. At least I mentioned my concerns on a government stranglehold, which I am not very happy with, and that would require necessary amendments if people in their wisdom think that it is required. The second aspect is that as and when the council lays down its own norms, lays down its parameters, whether they can be in view of the recent amendment, whether that should also be an aspect put in public debate, I would say. So it will facilitate, because a lot of things have been left loose for the council to do. And the third aspect is that the council must play an overarching role and not get into the nitty-gritty. Otherwise, the concern which both of us have expressed is that we don't need another regulatory body.
Mr. Khambata.
The Section 34 court is the best regulator. You don't need any other regulator. That's the and the law tells us exactly what the confines of Section 34 are. I think it's easy enough to tweak this part by going back to what the Sri Krishna report had basically recommended. If they go back and weed out what has been added and maybe re-emphasize certain portions, that's all that's required. You don't need to set up another committee and go into all this all over again. I think you have a template given. You should just follow it.
Couple of steps backward instead of couple of steps forward.
I think so.
Amit?
Yeah, right. So I think, at least for me personally, I think this is one area where, despite the plethora of webinars we've had in the last few months, this is at least an area I thought which had really not witnessed enough debate and discussion. So at least from a very personal standpoint, there were so many of my doubts or apprehensions which I had in relation to this particular proposed mechanism, and which, thanks to our expert speakers today, I think all of us have far more clarity in terms of what are the pitfalls and possibly what are the pros in terms of this mechanism which we propose to adopt in the years going forward for the arbitration ecosystem. So in order to formally conclude today's session, I would request Mr. Amarjeet Singh Chandiok, Senior Advocate and former Additional Solicitor General of India, as also the President of the Madhyam, to kindly propose a vote of thanks. Over to you, sir.
Thank you, Amit. Thank you, Mr. Garg. I'm grateful to my Lord Justice call. In fact, Lordship took me back to the time when your Lordship was practicing in Delhi High Court, and one were opposing, looking at the arbitrations and how we were doing, and this change the litigation has brought it. In fact, during your Lordship's tenure, even as an honorable judge, we found the change that has brought it. And I must say with sense of pride that, but for the vision of my Lord, we would have not seen a Delhi High Court arbitration center, international center, as well as the mediation center. And thank you so much for giving all this clarity today on the Arbitration Council. We don't need a regulator. We have so many regulators in the country. In fact, everything is getting regulated now back into what we were doing earlier. We don't need another regulator now to have that. Mr. Khambata takes me back again. You know, we have known each other for years together. And ever since we knew each other, I don't think there's been any occasion when we have not spoken to each other or exchanged our views. Thank you so much for joining us today. On behalf of everyone in Madhyam, we must thank you for giving us overview, the pitfalls, what we should look at, what should be the arbitration council ultimately. And in fact, it gives me an idea. And now that I know this is Call's view, I'm looking forward for the mediation code or act, whatever comes, would probably bring a mediation council with that advisory role to see how mediation process will take place, especially after we have signed Singapore Convention, and now we have it in place to see how mediation settlements can be enforced like we have arbitration. Thank you, Amit. Thank you, Mr. Garg, for being moderators. Excellent session. And I'm sure all our participants have enjoyed themselves and have learned so much from all what we have seen. A lot of clarity has come to us, not only for arbitration, but also for other systems that we have to adopt. Distinction between domestic arbitration and international, and why do we behave differently when we go to two different forums. All that we need to amend, and I'm sure it will go a long way to establish how we take this arbitration. In fact, I was looking at today's webinar, and I want to tell both Mr. Garg and Mr. Amit that it gives me back what I saw the Chief Justice Menon of Singapore and Justice Kanan telling me one day, that you should have an honorable judge who is conversant with that law to be actually one of the persons who's going to help government enact a law. You would see the change that it looks at. You must have experts who are dealing in that subject matter to be on the panel to look at and advise the government what they should do. And I see every change that has brought in. See insolvency in Singapore, see the arbitration, see the mediation. Everywhere we found an honorable judge and the experts in the field joining hands to advise the government and the government accepting it. But here we have a recommendation even from a committee where honorable retired judge was looking at it. That has not been given a go by. We hope and expect the government will look at it. Probably we'll see some of us who can reach to the government through this webinar can go back to the government and suggest if they can rewrite chapter 1, capital A, and probably look at it. One more sentence and I'll finish it. If you 43D also carries mediation. That means the arbitration council will look at mediation also. Whereas mediation is not the subject matter of the act even. So therefore, these are things that we need to look at. And I'm sure time would come ahead that we will probably gain from the experiences that we have got from everybody. Thank you, each one of you. Thank you, participant. Thank you, my lord. Thank you, Mr. Doris. And thank you, Amit and Mr. Garg. Thank you so much. God bless.
Thank you
So much, sir. Thank you so much.
Thank you.